about what the Supreme Court vacancy will mean for women and girls, and especially for women and girls of color. So first, I want folks to really pay attention to the fact that healthcare access is really at risk right now. I know many of you already know about the ACA case that's expected to come 1 week after the election. The Supreme Court is expected to hear oral arguments for California v. Texas, a lawsuit brought by a group of states that oppose the law and is led specifically by Texas. And the goal of this lawsuit is to dismantle the entire ACA, something that Congress has refused to do multiple times, and yet this lawsuit is aimed at using the courts to dismantle it. This case could jeopardize access to healthcare for at least 20 million people in this country. The ACA was a landmark legislation that provided protections for people with pre-existing conditions, and this includes nearly 7 million people who have tested positive for COVID-19 in the US. The ACA expanded Medicaid and coverage for preventive services. The lawsuit and ultimately this next Supreme Court justice will determine whether the ACA stands or whether healthcare becomes even more inaccessible to many people. The risk to women in particular is really high if the court were to invalidate the ACA. This is because the ACA, in addition to all the many things that it provided, it also ended widespread discrimination against women. And in particular, it ended the practice of insurers charging women more for the same coverage, and it stopped insurers from denying coverage from pre-existing conditions, like having been pregnant or having had a C-section. It also made sure that plans would cover services that women needed, like maternity care, birth control, and it also prevented sex discrimination in healthcare. The reason why this is a really important case to lift up is twofold. In part, Trump has promised to nominate only justices who would dismantle the Affordable Care Act and overturn Roe v. Wade. And he is delivering that promise by nominating Amy Coney Barrett. The reason why we are particularly concerned about Amy Coney Barrett is that she has had a record of criticizing the Affordable Care Act. In 2017, in an essay, she criticized the 2012 decision that upheld the ACA, NFLIB v. Civilis, saying that the ACA was pushed beyond, quote, its plausible meaning to save the statute. In another moment, she also referenced the 2015 Supreme Court case that upheld the law, during which she said that the dissent had a better argument. These statements, and among other things in her record, really give pause to us and should give pause to everyone on this call, on this video, because it gives us every reason to believe that if she were confirmed, she would vote to strike down the ACA.
Thank you, Teresa. Now I'm going to turn it over to Felicia, who's going to talk about access to reproductive health care, which will also be at issue if Judge Barrett were to be confirmed.
Thank you, Erin, and thank you, Teresa, for doing a fabulous job of framing why the Affordable Care Act is so important. We are aware that health care and reproductive care access is arguably where Judge Barrett's record shows the greatest threat to Black women. Though Black women and other women of color have attained some gains since the passage of the Affordable Care Act, those gains are at risk of being erased should the court strike down the law. Moreover, the loss of no-cost contraception, well-women visits, preventative health screenings, and abortion access has far-reaching generational consequences for women who are already vulnerable to health disparities and undue financial strains. It is now widely known that the ACA and various reproductive health rights are at risk should the Senate confirm Amy Coney Barrett's Supreme Court nomination. There are 17 abortion-related cases that are on their way or could be heard by the Supreme Court. And the impact of an ultra-conservative court on Black women who will undoubtedly bear the brunt of restrictions and access to healthcare services cannot be ignored. Black women are already disproportionately uninsured, suffer higher rates of maternal and infant mortality, and lack access to a variety of reproductive healthcare services. Currently, Black women of reproductive age face the biggest coverage disparity among all Black women. Just 86% of Black women of reproductive age have health insurance coverage compared to 95% of Black girls and 98% of Black women ages 65 and older. Health insurance coverage is critical to better health outcomes for Black women who face outsized risks of maternal mortality. Black women die from pregnancy-related complications at 3 to 4 times the rate of white women, and the death rate for Black infants is twice that of white infants. While structural racism across all facets of the healthcare system contribute to these figures, pregnant women who lack coverage often delay or forego prenatal care in the first trimester, and inadequate prenatal care is associated with higher rates of infant and maternal mortality. Aside from losing access to free birth control and various reproductive health screenings, should the court strike down the ACA, Black women will certainly bear the brunt of restrictions to abortion access. As a preliminary matter, Judge Barrett has expressed a fundamental belief that Roe v. Wade should be overturned when she signed on to a 2006 letter calling for, quote, the end of the barbaric legacy of Roe v. Wade. A decade later, Judge Barrett modified her position, stating that, quote, I don't think that abortion or the right to abortion would change. I think some of the restrictions would change. I think the question is how much freedom the court is willing to let states have in regulating abortion. Though Judge Barrett's approach to abortion rights may no longer be extremely laser focused on Roe, she seems poised to paralyze abortion rights by restricting access to abortion clinics. Many laws regulating abortion clinics are so onerous that compliance is nearly impossible, effectively eliminating the right to abortion in many states where clinics have been forced to close. Despite these restrictions appearing race neutral on their face, it is Black women and other women of color who are most impacted. When abortion clinics are forced to close due to onerous restrictions, women must travel great distances to reach the nearest abortion clinic across state lines or in far corners of their state. Coupled with other abortion restrictions in some states, such as a mandatory 48-hour waiting period in between appointments, obtaining abortion care often requires a multi-day trip hundreds of miles away from home. Women of color are least likely to overcome such barriers and are consequently denied access to abortion care at a greater rate than white women. In addition to allowing states to enact onerous restrictions on abortion clinics, Judge Barrett has also expressed a willingness to invalidate laws that purport to prevent abortions on the basis of race, sex, and disability. These laws prevent doctors from providing abortions to women who suspect they are seeking an abortion for one of the aforementioned reasons. Judge Barrett has already weighed in on this issue by joining in on an opinion in the 2018 case Planned Parenthood of Indiana and Kentucky versus the Commissioner of the Indiana State Department of Health, where she joined a dissenting opinion stating that until a fetus is viable, a woman is entitled to bear a child, but there is a difference between I don't want a child and I want a child but only a male, or I want only children whose genes predict success in life. That opinion expressed doubt that the Constitution bars states from enacting laws preventing parents from using abortion as a way to promote eugenic goals. And this is an opinion that has also been shared by Justice Clarence Thomas. Ultimately, it is clear that Judge Barrett views the erection of barriers to abortion as a means of achieving near eradication of abortion rights in the United States. But this method will result only in a two-tiered system of abortion access, one where wealthier, mostly white women will be able to overcome the financial and logistical barriers and exercise their rights, and where low-income women of color may be unable to do so.
Hi, thanks, Felicia. I think that's a really, really excellent point that you made. And I also wanted to add a little bit more to fine tune what you just said about Judge Barrett's record in particular. I know that she's ruled on a number of cases that relate to abortion, and particularly I think they demonstrate a really troubling approach that she takes in her eagerness to overturn key Supreme Court precedents, as well as, agree to many restrictions to abortion. in abortion care. And this is especially troubling because abortion is already being pushed out of reach for many. And her addition to the court, while, you know, I think you quoted her saying that it may not be a direct overturning of Roe, I think it's really, really important to lift up that, you know, they can really chip away at the protections that it's supposed to give. And if you're slowly chipping away at Roe and the protections by approving restrictions, approving different methods that are meant to harm women of color and keep them from being able to access that care they need and they choose to have, that is extremely troubling and something that we certainly should be paying close attention to during Judge Barrett's hearing. Thanks.
Thank you, Felicia and Teresa, for that very helpful overview. I think it's also pretty scary about Judge Barrett just because of her lack of respect for the rule of law and her approach to stare decisis in terms of thinking that, you know, if there is some, she's willing to overturn key precedents that she believes were wrongly decided. So I think Roe is definitely very at risk going forward if she were to be confirmed. So now we're going to switch and talk a little bit about education. Teresa, can you share a bit about the Title IX case that Judge Barrett decided on?
Yeah, absolutely. And I think before I start talking about the specific case, I kind of want to lay the groundwork for why Judge Barrett would pose such a significant risk to students, and particularly student survivors. Part of it is in the last 4 years, we've definitely seen the Department of Education weakening protections against sexual harassment in schools. Specifically, you know, we've seen over I think it's been since 2013, about 600 cases have come through the courts from like students and professors who are held accountable for sexual misconduct, and in turn are actually going around and suing the school for that accountability. And so, and a lot of these cases in particular have been propelled by extremist men's rights groups, mostly asserting due process violations or even using Title IX itself and suing the schools, saying that they've been discriminated against because they are male. And so, you know, I want to lift that up because I think it's really important to lay out the groundwork that these are not issues that are just theoretical, but are truly ones that are making their way through the court, and potentially something that Judge Barrett could rule on. Specifically, I want to talk a bit about Judge Barrett's opinion in Doe v. Purdue. This case really made it easier for those who are held accountable for sexual assault to sue their school. And so, you know, the background of the case really is John Doe was suspended from Purdue University after the university concluded that he had sexually assaulted another student. And what John Doe alleged in his if what John Doe had alleged in his complaint was true, then it sounds like, you know, I'll first admit that it sounds like Purdue may have not given enough care to his investigation. And so, you know, I want to take a pause and not focus too much on the facts of the case, but focus more on Barrett's reasoning, because I think that Barrett's reasoning in this case really does signal a very troubling approach to how she would take on this case and on other cases similarly. For the main holding in this case, Barrett believed that John Doe could proceed not only with the due process claim that he filed against Purdue, but also with a Title IX sexual discrimination claim. And I think, you know, I'm going to start by talking a bit more about the Title IX sexual discrimination claim. Basically, the plaintiff in that case believed that he had been found guilty of sexual assaults on campus because of a anti-male bias that the school had been and he had thus treated him unfairly. And so, you know, the reason why I think this approach and why Judge Barrett's decision in this case is particularly troubling, because first, her decision allows for men who have been disciplined for sexual assault to use Title IX, which is a statute that's intended to protect people who are, you know, victims of sexual assault and sexual harassment, and instead to allege that instead the school was motivated by the perpetrator's sex in imposing the discipline, i.e. Suspending them from school. And so I think that that is something that the Law Center has been doing a lot of work on to support, but in particular, it's her approach suggests that the school's responsibility for complying with Title IX was forcing them to be biased against males. And in supporting her reasoning in the case, she suggests that she argues that one instance where a female student was believed more than a male student is really wholesale evidence that the school exhibited anti-male bias. And I think the reality is that for a lot of sexual assault survivors, who happen to be women and girls, are typically held in a much higher standard and required to allege a lot of facts to show that their school had treated them with deliberate indifference, and that the school was, that failed to act on their behalf. And so I think that that is one issue that is pretty troubling, is that with this one instance of where the school believed the female student more than the male, that was enough evidence to show that there was anti-male bias. A second piece of evidence that she used and weighed heavily in her decision is a Facebook post that stated that men are responsible for sexual assault. And I think that this is also a particularly troubling factor in the case, because it, the statement came from a campus office whose role is to really advocate for student survivors, and they don't really have a decision-making authority over that case, over how the school treats the person who is being held responsible for sexual assault on campus. And so those two pieces of evidence were enough for Judge Barrett to believe that the school had been discriminating against this male student. I think what's another issue that is extremely troubling about her decision in that case is that she really relies on sex stereotyping. She very much leans into the fact that thinking that only men commit sexual assaults and only women can be survivors. And I think that that is a particularly troubling viewpoint when you think about the different cases that are coming up through the pipeline, and the fact that I think there's also a lot of effort to discredit survivors by claiming that there are a high number of male students who are falsely accused of sexual assault, when in fact there are more men who are victims of sexual assaults than those who are falsely accused. And so I think those are really important. Judge Barrett's reliance on sexual and sex stereotyping is particularly troubling. I think the last piece that I want to really highlight is that Barrett really eased and simplified the legal standard for whether male students can claim that they're victims of sex discrimination when they're found responsible for committing sexual assaults on campus. The reason why I want to lift this up is because I think, as I mentioned earlier, there are a number of cases that are making their way through the pipeline that are discussing discussing how schools should be taking sexual assault seriously on campus. And so the idea that taking sexual misconduct seriously, for schools to take sexual misconduct seriously, suggests that there's sex discrimination happening against men is a disservice to all survivors, male and female, and just really a gross misinterpretation of Title IX. Judge Barrett's opinion in Purdue makes it so it really turns Title IX on its head and transforms a law that is intended to prevent, forms of sex discrimination, and instead using it to protect students accused of committing it. And so I think that is an extremely troubling viewpoint that Judge Barrett displays in her decision in this case. And it really is a dramatic departure from what the Title IX protections were intended to do, and were put in place to really ensure that students were protected in the school environment. Thank you.
Thank you, Teresa. I also want to point out another troubling aspect of her viewpoint on Title IX is that it doesn't extend to transgender Americans at all. She shared that it would be, quote, straining the text of the statute to say that Title IX demands it in a 2016 lecture she gave at Jacksonville University. And that's directly out of line with what we saw in the Bostic v. Clayton County Supreme Court decision earlier this year, where Justice Gorsuch, writing for the court, held that Title VII's protection against discrimination based on sex extended to gay and transgender individuals. And Justice Gorsuch explained the quote, "Those who adopted the Civil Rights Act may not have anticipated its application to these communities, but only the written word is the law and all persons are entitled to this benefit." So I think that even though she has a originalism and strict textualist approach to her judicial philosophy, it definitely seems like she's a bit out of step on her position on Title IX not being extended to transgender individuals. Now I'm going to turn it over to Felicia, who's going to discuss some of the employment discrimination cases that Barrett has decided.
Thank you again, Erin. And I think it's really a great transition that you brought up Bostic and talking about what makes Judge Barrett's record so dangerous for employee protections, excuse me. On the surface, Judge Barrett's record on employment seems to be less detrimental than her record on some of the other things that we've been discussing today. But a deeper look at her record shows that she would greatly harm employment discrimination litigation. Although she has not authored many opinions on employment issues, most of her opinions suggest that she would be willing to side with employers over employees in employment disputes, particularly on key issues that we litigate against, including wage issues and employment discrimination cases. This poses a particular danger for Black workers and other workers of color who are more likely to be hourly wage workers, experience pay disparities in both hourly and salaried employment, and to bring race discrimination cases. Erin previously sort of discussed the Bostic case, and a lot of Judge Barrett's opinions on Title VII are really, really troubling. And I want to just give a little bit of framework around Title VII. It is a critical statute that is used to bring claims against employers for discrimination on the basis of sex, which after March of this year now includes gender identity and sexual orientation, but also on the basis of national origin and race. And these types of cases help to ensure that employees have access to a work environment that is free not only from discrimination, but also harassment and retaliation should they bring a claim of discrimination against their employer. One case that has received a lot of public attention and discussion is the Eeoc versus Autozone case, which was a Title VII race-based discrimination case that alleged that Autozone was violating a provision of Title VII that makes it unlawful for an employer to limit, segregate, or classify employees in any way which would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect his status as an employee because of such individual's race, color, religion, sex, or national origin. And in this case, a Black employee alleged that the auto parts store was moving employees from one store to another store that was more representative of the race of the employee. So in this person's case, he was a Black employee who alleged that AutoZone moved him from a store in a largely Hispanic neighborhood, and in addition to relocating him, reduced his pay. The employee abandoned his job and filed a complaint with the Eeoc, and the Eeoc chose to file suit. AutoZone moved for summary judgment, and the district court granted their motion. And on appeal, Judge Barrett voted against a request for rehearing, essentially denying the Eeoc's request for a full court to reconsider the case. And so this demonstrates that Judge Barrett, if given the opportunity, is highly unlikely to side with employees to allow them to bring their case before the court in order to have their claims heard. And when the Eeoc decides to step in and bring a case, that is almost a sure sign that there is obviously a problem with the employer's record or with the actions of the employer. And so for the court to deny the employee their opportunity to have their case litigated and heard before a court of law is essentially denying employees the ability to bring grievances against their employers. This risks setting a very dangerous precedent where employees either feel as though they have no legal recourse because their cases won't likely be heard before the court, and then therefore are less likely to bring their case or attempt to bring their case, or it will set a precedent where employees are bringing their cases before the court, but their cases aren't surviving summary judgment and are ultimately not being heard. In another case where Judge Barrett actually penned the majority decision, Smith versus the Illinois Department of Transportation, we get a little bit more of a troubling insight into her actual leanings on the merits of Title VII cases. In this particular case, an employee was alleging a hostile work environment and retaliation based on claims of racial discrimination. The plaintiff in that case was a Black man who alleged that he had been yelled at, had profanity used against him, and was referred to by a racial epithet at work. Writing for the majority, Judge Barrett affirmed a summary judgment motion and excluded very key evidence, holding that the use of profanity towards a plaintiff towards this plaintiff was not connected to his race, and that the plaintiff failed to offer evidence that the use of the racial epithet towards him, quote, changed his subjective experience of the workplace. And once again, this sets a very dangerous precedent, and it gives us an insight into Judge Barrett's thinking around race-based discrimination cases, to believe that a Black employee who has profanity used at him, who has racial epithets used towards him at work, is not in some way experiencing a subjective change in the environment that he is working in. The bar for Title VII claims is already, I would argue, unreasonably high in being able to show that the actions that are taken against an employee are actually in some way detrimental to that employee's ability to conduct their job. But in holding specifically that the use of profanity or the use of racial epithets are not somehow meeting that incredibly high burden to that incredibly high burden set by the court already, demonstrates that there is virtually nothing that an employee could demonstrate that would show that they are being harassed at work, or that they are in some way being impacted and affected in their ability to do their work by the use of profanity, by yelling, and by the use of racial epithets. And so if these sorts of cases are able to make it to the Supreme Court and are heard before Judge Barrett, there is a high likelihood that she would not vote in a decision that would be favorable to an employee, and would set precedent that would permit employers to engage in discriminatory actions or allow discriminatory actions to continue at their workplaces to the detriment of Black employees.
Thank you, Felicia, for that. I want to point out that there was a really powerful dissent in the Autozone case, written by Judges Diane Wood, Judge Alana Rovner, and Judge David Hamilton, where they said, quote, under the panel's reasoning, a separate but equal arrangement is permissible under Title VII, as long as the separate facilities really are equal, which is kind of scary considering just the comments that Judge Barrett has made around Brown v. Board and the concept of super precedents, and just what that means for her judicial philosophy around originalism. So now I'm going to turn it over for questions. So if you have any, you can please feel free to submit them in the Q&A. We have a couple already. The first is asking if there is any kind of injunctive relief that can be filed to stop the hearings for the Supreme Court seat, due to the fact that we've been in the election since September 4th, when North Carolina sent out ballots, and Justice Ginsburg died on September 18th, 14 days before, I think they mean 14 days after the election began. And this will be the first time the Senate has tried to seat someone during an active election. So I'm not aware of any current injunctive relief. I'm not sure if Teresa or Felicia are aware of any. I see them shaking their heads no. Right. I think for what's kind of striking about this process is that it just hasn't occurred before, but there isn't necessarily a law preventing it from happening. I think the closest occurrence that we have is back in 1864, when President Lincoln was presented with a vacancy in October before the election, following the death of the Chief Justice. And he waited until the following December to appoint someone after the election results had been decided. And that was with President Lincoln was a Republican, and he had a Republican majority in the Senate there. And so I think that's the closest we have. We haven't been in this sort of situation beforehand. I see another question that says, what can we do? I think we have to be engaged and make sure that you're contacting all of your senators for whichever state you reside in to let them know your thoughts and opinions and any concerns that you have on Judge Barrett's nomination. Felicia and Teresa, do you have anything you want to add for what folks can do?
Absolutely. Well, I'll start, and please feel free to chime in, Felicia. I think it's really important for us to fight this as much as we can. I think it's important for us to show that, this seat matters, that the Supreme Court matters for all the issues that we talked about earlier, particularly for people who are most marginalized. And I think that we need to really lift up why this nominee in particular would be so troubling. So, and I think, it's whether it's participating in virtual lobby days, whether it's calling your senators, whether it's signing on to different sign-on letters, doing op-eds, lifting up your, I think it's also story telling and like story sharing is a really important advocacy tool right now. Talk about, if you have a COVID story that you want to lift up and explain why, ask the senators, why are they not focusing on COVID relief as opposed to trying to advance this very dangerous Supreme Court nominee. I think there are so many different pieces and activities that people can engage in that, to lift up your voice and lift up the issues that matter the most to you.
And I'll just echo what has already been said. I think that it is really, really critical not only to be informed about the issues and the issues that matter to you, but also to speak up and to speak loudly and to speak often. I think oftentimes people feel like if they, call their senator one time or they write a letter, that is enough. But I would argue that at this point in time, this is an emergent situation and it's an all hands on deck, and it needs to become sort of a daily part of your advocacy routine to reach out to legislators, to voice your concerns, to continue to express your dissatisfaction with this particular nominee, and to push the committee to not vote on this particular nominee, and to ensure that whoever is elected on November 3rd, that person has the opportunity to nominate for the Supreme Court. And I think that the more that people voice their dissatisfaction about the process, about the hypocrisy in this particular nomination process, given how things played out in 2016, I think that it is really, really going to come down to people pushing and fighting tooth and nail to ensure that the Senate understands that this is not the will of the American people.
Thank you. We have another question asking whether or not we will share the recording of this webinar, and yes, we will share it to the Lawyers Committee website, and we're also broadcasting it on our Facebook page as well. I see another question. Can you put into bullet points your points about Barrett's concerns, and if you cite the cases? And are the senators hearing these points? So the Lawyers Committee, the National Women's Law Center, and a lot of our sister organizations have all been in contact with the senators and raising these concerns. The Lawyers Committee, we're currently finalizing our report, which will be public next week, and we're also sharing that with the Senate and the Senate Judiciary Committee staff so that they're aware of all of these issues, and we go a little bit more in depth for all of the racial justice issues. And there's a lot in her record that we wouldn't be able to fit into this briefing today, but I encourage you to check out the Lawyers Committee's website and sign up to receive our email so that way you can know when our report is public. Teresa or Felicia, do you want to add anything for that? No.
Sure. I will try to post our website too that we have right now called We Dissent, the Fight to Block Barrett. In particular, we have a number of fact sheets available both on our record as well as lifting up the different pieces that are at stake. And a lot of them are being finalized by the end of the week. So if you check out the website tomorrow, there will be probably twice as many documents as there are now.
Sorry, I was muted. I see a question asking if there are any members of the majority party in the Senate Judiciary Committee who you feel are the best ones for us to reach out to raise concerns about the nominee. I would just reiterate, I think that everyone needs to be contacted. All of the senators on the Senate Judiciary Committee, all of the senators, all 100, just because they need to know how people feel about this, that people are educated, that people care about the Supreme Court, and they care about this seat being potentially filled while the election is ongoing. So I would just reiterate that you should contact all of them, and in particular the senator who represents you. Teresa and Felicia, you can feel free to add anything for that if you want.
I'd say also, if you email the Senate Judiciary Committee directly, there are a couple folks who are reading, especially opposition letters, op-eds, pieces that that might be good to lift up during the hearing or to have read out loud during the hearing. So, you know, happy to connect with, if you connect with me or Aaron, I'm sure we can direct you to the resources that and the contacts who might be interested in those letters.
See, with the delay of the Senate due to COVID, how likely do you think that it is that there will be a vote appointment prior to the election? Teresa, do you want to take that?
I'd say very likely. Unfortunately, this process is moving very, very quickly, and the Senate majority does not. There are no signals that the Senate majority is slowing down, despite, as you mentioned, the COVID outbreak, as well as the outcries of a lot of the community in terms of moving this nomination so quickly. Right now, the schedule is still as expected that next week will be the hearing, markup vote that Thursday, a markup vote holdover, and then the week after will be a vote out of the committee, and then a week after would be the confirmation vote, which would be the last week of October.
Thank you. And I see, can we expect any other conservative justices to rule and surprise us like Gorsuch did in the Bostic case in any of the upcoming cases that the panel has highlighted? I think my initial response to that, and Felicia, you can, and Teresa, you can obviously chime in, is that I think that a lot of the civil rights litigators are, adjusting their strategies to appeal to the justices. And I think that's why the Bostic case it was very clear cut that, that the discrimination was on the basis of their sexual orientation and their gender identity. And it was very clear cut. So I think you'll just see more creative arguments out of litigators before the Supreme Court to continue fighting the fight to hopefully get decisions that continue to protect our civil rights and constitutional rights.
Right. And I will flag too that some of the cases that we've mentioned a little bit, but also, obviously the ACA cases, as Felicia mentioned, there's a number of reproductive rights and health cases in the pipeline. And a lot of these cases were 5-4, particularly if you think about June Medical, which is the case that just came before this last term, as well as the birth control ACA case. Those two were also 5-4. So I think that is a particularly troubling sign in terms of what the makeup of the court will look like with the addition of Amy Coney Barrett.
And I think that Aaron is correct. We have, we worked on submitting an amicus brief in the Bostic case, or the trio of cases that we're referring to simply as Bostic. And one of the conversations that we had in thinking about how to present our arguments before the court was looking at, the text and becoming more textualist and becoming a little bit more originalist than I think civil rights litigators tend to be. And so I think that for people who are following these cases and who are following the way that the justices tend to come down on these various issues, we were a little bit less surprised, I think, than the general public on the decision and who cited, I think correctly, in determining that, you know, sexual orientation and gender identity are protected under Title VII. So I think going forward, we as civil rights litigators and as advocates and as people who are presenting briefs before the Supreme Court are going to be thinking more about how we can make textualist arguments, or how we can make arguments that traditionally have not really been in the toolkit of civil rights litigators to prove to the court that the rights that we want to see protected and upheld continue to be protected. So I think there will be opportunities and there will be times where I think that the justices will kind of vote the way that they tend to vote, but it might come as a shock to the general public or people who aren't typically following these sorts of cases, or might not be as familiar about what the particular issue before the court is. And then there will be other times where I think we'll have to be extremely creative in the arguments that we present before the court, and really hope that we are more persuasive than the other side.
Thank you. So we are at time, and I apologize that we were not able to get to all of the questions. And thank you all for joining us today. If you have any follow-up, you can please feel free to email me at emartin@lawyerscommittee.org. And I'm sure I'll leave it up for Felicia and Teresa to share their email addresses as well if you have any follow-up questions.
Yeah, this is Teresa, and it's just tlau@nwlc.org. Trying to figure out how best to paste the website link that I had. I'll just put it in the last answer, and hopefully folks will be able to see it.
Yeah, that's the one downside to not having the chat open on the Zoom.
And my email, similar to Erin's, is phill@lawyerscommittee.org.
I want to thank you again for joining us today, and thank you to our wonderful panelists, Felicia and Teresa. And I'm so glad that the Lawyers Committee was able to partner with the National Women's Law Center on this briefing. Thank you. Bye, everyone.